Alrighty. Hi, everybody. My name is Rebecca Nilsen. Please welcome to our webinar on cybersecurity breaches, your business's legal responsibilities. I am a senior associate here at LegalVision. I have been working in the industry advising commercials for about 13 years now. Unfortunately, have been through some cyber incidents. So we have lots and lots to share with you today to hopefully make sure that we make the most of you giving up your valuable time to spend with us. I'm joined today by my colleague, Tayler Berridge-Smith, who has also been advising in this space for quite some time now and is very, very knowledgeable on the different things that can really impact you on a day-to-day basis. Before we begin, we've got a couple of quick housekeeping items to go through. So you will receive the recording and slides in your email, so there's no need to feel stressed or rushed as we go through it. You can submit your questions in the Q&A box and we'll attempt to answer as many of them as we can at the end. We don't really have time to do it in flow during the webinar, so if you pop them in there, we'll try and get through them once we finish. And please complete the feedback survey after the webinar. It really, really helps us just amend our future webinars, make sure that we're responding to what you find most helpful and most important, and deal with anything that you find annoying, quite frankly. So those are very, very helpful for us in our continued provision of these types of webinars. When you view these webinars, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim, you just have to leave your contact details in the survey that will appear when the webinar ends, or you can contact us via our website. We do have all the registrants' details, so we just match those together. We have a poll question for you as well before we get started, which is how prepared is your organization to respond to a cyber attack? Either fully prepared, you've got a clear response plan in place, somewhat prepared, you have an idea, but maybe you need to improve it, not prepared at all, you have nothing in place and not really sure where you sit in that, so you'd like to learn some more. Today, as we go through our agenda, we are going to go over all the legal obligations you have in the event of a cyber attack, how to go about managing your cyber risks, cyber attack and privacy breach notification obligations, which is very key in terms of your planning around cyber attacks, a summary, and then our Q&A at the end. I'll just give everybody a moment to get those poll questions in. All right, so it looks like one or two of you feel fully prepared, which is great. That's awesome. Hopefully we're still able to add some value here for you today. There's quite a few of you that are somewhat prepared, so you have some awareness around, cyber breaches, but you probably just want to validate that you're doing the right thing or look at some ways to improve. Hopefully, again, we'll be able to add something for you there. Not prepared, you don't have a plan in place. Great, you're starting by being here today and not sure you'd like to earn more. There's a few of you in that category too. So it does sound like for the majority of the people attending today, you have some awareness, but you would like to make sure that you're filling in those gaps. So we will try and tailor our conversation around that as much as we can, while still covering off on those of you who already feel like you know it all and don't know anything at all at the other end. Alrighty, so we will start getting into the meaty part of our webinar now, and I will get Tayler to start kicking us off.
Thank you, Rebecca. So the Crimes Act 1961 is the main piece of legislation that applies to cyber attack crimes in New Zealand. For example, it is a crime in New Zealand to access a computer system without authorization, to damage or interfere with computer systems, or to dishonestly obtain personal information. In terms of support that's available to companies in the case of a cyber attack, there is a New Zealand government organisation, CERT NZ, that provides advice, support and guidance to businesses and individuals affected by cyber security incidents. And they have a number of very helpful resources and guides on their website, and you can also contact them directly. In terms of your legal obligations in the event of a cyber attack, it is not illegal in New Zealand to pay a ransom. It's not prohibited, but it is strongly discouraged by the New Zealand government. Ransomware attacks are a criminal act and should always be reported to the New Zealand Police. As I touched on CERT NZ earlier, they recommend the following process. So ensuring that you record all important details surrounding the attack, you turn off the infected device and disconnect other devices to isolate the infected system, change important passwords, recover information, remove the ransomware or the information, and then notify and report as required. In terms of your legal obligations towards your staff, your customers, and your suppliers, and any other third parties, generally the primary obligation is your notification obligations. So in the event of a cyber attack, you may need to notify the Privacy Commissioner, as well as any affected individuals whose personal information has been accessed. But that will vary depending on the information which has been accessed via the cyber attack and the likelihood of the cyber attack to cause serious harm to those affected individuals. And we'll explain kind of what serious harm means later on in the webinar. In terms of your contractual obligations with your third parties or your customers, your requirements in the event of a cyber attack will vary significantly depending on your contracts. So a number of contracts, particularly where cyber crimes or cyber attacks are a key concern, will contain provisions that require you to follow set processes in the event of a cyber attack, or to notify your suppliers or third parties as and when required. So in the event of a cyber attack, you should always kind of try to determine who's been impacted and then review any contracts that you've entered into to make sure that you're complying with the provisions of that contract. And I'll now pass over back to Rebecca to touch on cyber risk management.
Okay, so there were some of you at the start that said you're not sure if you have a plan, or you do have a plan, but you feel like it needs to be more robust. Managing your cyber risks really is predominantly through going through making a plan. And there's two benefits that I see to that for a lot of our commercial businesses. The first being that as you go through your business and assess all the areas that you have cyber risk, you have an opportunity there to try and build up your own resilience against cyber attacks. So identify all of your vulnerabilities and making sure that you have done the best you can within your budget and the commerciality of your business to make sure that you have sort of patched those. And by turning your mind to them, it's really common that some of our clients will have those kinds of vulnerabilities just because in the process of running a business and scaling, it's so easy to miss out on just being really diligent in that space. You're focusing on growing a business. We get it. But going through that process is really helpful. And it can try and prevent harm from happening in the first place, which is always the best part of advice, is making sure that you're preventing harm from happening in the first instance. So that's one of the key benefits of going through this process and making sure that you do have sort of a robust plan in place, because you're going to identify those vulnerabilities during that exercise. The second one is really around identifying your operational risks and legal risks, and then having that documented plan in place. Not only does that reduce the panic that people experience when they realize that they are having a cyber attack, it means that you're going to vastly mitigate some of those damages that happen when this occurs. The most common response we have when somebody has a cyber attack is to contact us in an absolute panic, going, I don't know what to do next. What do I do? What do I do? Who do I call? And by having this documented plan in place, it means that you can sort of calmly step through it, know that you're taking the appropriate steps, and you can then contact the support people you need, which might involve your legal advice, which Tayler will talk about shortly when it comes to some of your privacy obligations and contractual obligations. It might involve having a trusted IT professional who can handle isolating the attack and making sure that they can adequately identify what's been affected by your business. But it also means that if you are away from your business, if you have stepped away, you're on holidays, you're unwell, you're dealing with family matters, there is a documented protocol that you can train your staff on to make sure that this is going to be handled in your absence. And it's going to be handled in a way that you, as the business owner or the trusted business advisor in this space, has deemed to be the way you would love this to happen if it ever happened to you. And obviously, we hope that nobody ever experiences a cyber attack, but being practical, we're in a modern world now, and it does happen far more often than people think. So that's the real benefit of going through a cyber risk management plan, is that you will have those two sort of key areas covered off on. So when it comes to identifying your commercial risks and legal risks, one of the big areas of legal risk is obviously breaches of privacy law, and it's one that's overlooked really often. So I'm going to get Tayler to have a chat to you now about privacy breaches.
Thank you, Rebecca. So in terms of what is considered a privacy breach in the eyes of the law, a privacy breach under the Privacy Act 2020 is the unauthorized access or disclosure of personal information or loss of personal information. So personal information is very broadly defined. It is essentially any information about an identified individual or an individual who is reasonably identifiable. So any information that you can use to identify one person. And it's important to note that that information can be considered personal information if it helps an individual be identified when combined with other information. So that obviously includes things like their name, phone number, address, email address, but can also include other information depending on the circumstances. A privacy breach may be caused by malicious action, human error, or a failure in security systems. So this could include things like loss or theft of physical devices, an unauthorized access by an employee of certain information, or a ransomware attack. In terms of when a privacy breach becomes notifiable, a notifiable privacy breach occurs when the following criteria is met. So there's been unauthorized access to or disclosure of personal information held by an entity. It is reasonable to believe that the breach has caused serious harm to an affected individual or is likely to do so. So serious harm can include physical harm or intimidation, financial fraud, including unauthorized credit card transactions or credit fraud, family violence, or psychological or emotional harm. So serious harm is quite broad, and once again, depends on the circumstances. In terms of when a privacy breach occurs and your notification obligations, notification of affected individuals and the Office of the Privacy Commissioner is required for notifiable privacy breaches. Other notification obligations may apply depending on the nature of your business or the category of information that has been unauthorized access to. The NZ Privacy Commissioner website has a really helpful tool called Notify Us, which is a self-assessment tool which can help you determine your notification obligations and who you will need to notify. In terms of the consequences of not reporting an eligible privacy breach, where you fail to report a notifiable breach, this can lead to a fine of up to $10,000. Additionally, the Privacy Commissioner can investigate the breach and may issue a compliance notice. Failure to comply with a compliance notice can also result in a fine. Rebecca will now be speaking about how to ensure you protect your organization as well as your customers.
Awesome. So as I mentioned, when you go through your planning process, the first place I start is always by saying you should conduct a vulnerability assessment. What does a vulnerability assessment look like? That's generally running through your business from end to end and assessing all of your systems, all of your procedures, all of the times that you are intaking or storing vulnerable data, and then assessing how well it's protected. Is there anything you can do internally to try and build up your protection around that data? Is it going to be upgrading your systems? If that's not possible or not within your sort of commercial assessment when it comes to spending money, then is there something you can do procedurally internally that's going to help prevent that? Are you going to be reducing the number of people who have access to that data? Are you going to be reducing the number of people who have passwords and what kind of information someone can upload onto your system? Are you going to be training your staff in a different way, or are you going to introduce sort of routine training sessions to your staff to make sure that they know what is confidential and not confidential and what to do in the event of a breach? That staff training is actually really key. A lot of the times we do see breaches occur where staff have perhaps logged on to a work system from an unauthorized computer, left it logged in. That's a really common situation, and that can result in sort of unauthorized access of the information. It can also mean that you then have logins and keystrokes being entered on a device that is not authorized by you or your business. So it hasn't been vetted. It doesn't have the appropriate security protocols in place. It's not something that's being as actively monitored. And that's all down to staff training. Those are all things that you can prevent just by having a really robust routine in-house process around how do we approach our data security. Once you have gone through that, then the second stage is having that breach response plan. So that's deciding what happens when somebody raises the flag, be it, because they've noticed it or because they have themselves, accidentally breached this, which is, its own sort of risk as well. What is it that you're going to do? Who are the people that they report it to? How is it going to be assessed? Do you have external help that will give you that guidance if you don't feel comfortable doing it yourself, be it your lawyer or using that privacy breach tool that Tayler's mentioned that's available on the website? Or is it, talking about other online resources that are available to you? So, for example, CertNZ are a government-run New Zealand resource that most of the time is free to use. The immediate actions when we have a breach need to involve quick and sure actions. That's why having a documented policy can make a really big difference in terms of how fast your business responds, because most people will still experience that fight or flight response when they realize that a breach has occurred. And that can really slow things down because everybody is panicking and looking in different directions instead of going, okay, I have a policy that's going to tell me how I'm going to approach this. So quick actions to identify and neutralize the threat. So if you have infected devices, making sure that they are isolated. If you have infected software, making sure it's disconnected from any of your other related internal services so it can't spread. And then contacting, if you aren't an IT professional yourself, contacting who will be able to repair that for you and identify the extent of the breach. Once you've realized the extent of the breach, that's when you'll be able to assess what yourself has been compromised in terms of your commercial data, but then also assess that privacy breach situation. So how far has this information gone? Whose is it? What's the damage? Perhaps look into your third parties to help you assess that, whether or not it's going to be something reportable. Then once you've done that, you can start looking at your commercial contract obligations. Is there anything that's happened? Do you have system downtime? Do you have any SLAs you're not going to meet because you have had this situation? Who are the key contract people that you contact, and how do you sort of manage that relationship in the intervening time? Because that's obviously not a legal risk, but it's something that really affects the commercialities of your documentation. So you might have something where you're down for a while. If you manage that relationship well, people aren't going to get really cranky that you're not meeting your end of a contract. But if you don't manage that relationship well and don't notify and you don't know who to talk to, then that can lead to downstream legal action, which you want to avoid, especially when this is something that was reasonably out of your control. And then the other thing is CertNZ does have a notification tool. We do encourage people to notify data breaches because that can help with systemic identification of risks across New Zealand that are happening. There is sort of global trends. I know that when in a prior life, when I was working in Australia, there was really good data that we used to be able to collect about where like really aggressive cyber attacks were coming from, and that would then help inform software response to those. So it's worth doing. You never know what it could help prevent somewhere else, or that could come back to you one day in a helpful way. Now, this actually concludes the main part of our webinar. We do have some time for questions. We do also have a free download available, which is around New Zealand notifiable privacy breach, which is just a fact sheet to help you internally if you're trying to decide whether or not you want to go down the notification pathway. Obviously, you can also seek professional legal advice on that if you're feeling uncertain. And you might also be interested in our upcoming webinar that's coming through, which is around Boardroom 101. So it's directors' responsibilities and liabilities. Obviously, some of these things that we're talking about do come back to director liability in terms of if you fail to identify these risks in your business and deal with them adequately, can fall back to the directors. That's on Tuesday, the 22nd of July at 12. We've got the link in the webinar for the registration, which will also be emailed to you after this one's concluded. So we'll be able to send those details through to you. We'll just have a bit more time for those questions to come in. I can see a couple popping through at the moment. In the meantime, I'll just let you know about the LegalVision membership. Obviously, when you become a LegalVision member, your business gets unlimited access to our full team of over 100 specialists, and we deal with all of your business as usual legal needs. So it's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of your business contracts, unlimited legal advice consultations. So you get to be face-to-face with me and other members of the team about your business on a regular basis as you need it, which is really helpful, and unlimited domestic trademark registrations and so much more. We find it really helps our members that they don't have to worry about the cost of lawyers. It's at a fixed rate. You're able to prepare for that. And when you have your own sort of in-house counsel, as it were, we get to take care of all that business as usual legal work so you can focus on the important things of running your business. If you are an in-house counsel, we do also have a dedicated service to help manage those high volume business as usual legal tasks, so you can focus on the big picture while we've got a team who manage all of the ongoing duties for you. To learn more about our regular membership or desk extension, you can just request a free consultation when the survey appears at the end of the webinar, and one of our team will be in touch with you in short order. Alrighty. We now have some of your questions that have come through. So, is there a plan for helping you to keep calm? One thing that does create insomnia is the potential trouble you could be in for a breach. I know that feeling. It's very, very common, and the thing we deal with the absolute most when someone calls us in a panic about a breach. The plan is basically making sure that you have that documented plan. I quite like that when you have a breach response plan that goes, we have identified a breach, here's what we do. It means that as you tick off each list, you're no longer going, I wonder if there's something else I should be doing. I wonder if there's something else I should be answering. I wonder if there's someone else I should be reporting to or asking for advice from. And if you've thought about all of that in a non-pressured environment where you're just in hypotheticals, thinking about what might happen, and then you document that on a step-by-step basis, from a practical perspective, it just takes so much of that away from the situation. Like breaches happen in businesses that are very well prepared for them, that have really reasonable systems and processes in place to try and prevent them. And ultimately, the law around breaches is fairly pragmatic in terms of that if you can demonstrate that you have gone through this planning process, you have put appropriate systems in place, you have taken the appropriate steps, you reported it quickly and in the correct channels, then the consequences are pretty, minimal. So having that plan documented, thought through, well advised, you've sought the advice you want in advance of a breach happening, that can really help just get rid of that lingering anxiety that might be floating along for a lot of you. Uh, you're welcome. All right. Director obligations and liability in this space. What sort of questions should directors be asking management about this subject matter? Whew, that is such a good question. If you are a director and you have outsourced management of this to a member of your team, it's really about assessing whether or not you think that that team member has the appropriate knowledge and experience and support to be able to put a plan in place. If the answer is yes, then you should be familiarizing yourself with the plan as well. Directors have an obligation in New Zealand to make sure that they are across all of their business. So it used to be that you could be a director on the board and you could have some relevant experience, but you didn't need to be that knowledgeable about your own business. That changed really quickly. A few years ago, we had a really big case. And it basically said that directors have an obligation to know their business. They need to know the industry it's in, they need to know the risks, they need to know how that's going to affect their customers as well as their stakeholders that are, your shareholders and things like that. So for you, if you've put someone else in charge of that, you need to make sure that you feel really comfortable about their qualifications and abilities to manage it. Then you should be asking what the plan is and if there's any documentation associated with it. And ideally, the directors should be across all of that and feel very comfortable that there is an adequate plan in place. There's no expectation on a director to know the ins and outs of being able to jump into your technology system and quarantine a threat and be able to do that IT specific work. But you really need to know if that risk exists, what's the plan? How are you going to deal with it? And is that really appropriate? Dealing with it is not sitting on it and waiting for 2 weeks. Dealing with it is being fairly prompt and being able to jump in and actually go and neutralize the threat, essentially.
I thought I'd jump in and answer Maria's question here. So what are the advantages of engaging with you as a lawyer when experiencing a data or cybersecurity breach? So obviously going back to Shannon's question before around kind of mitigating the stress relating to a cybersecurity breach, often it can be helpful engaging with lawyers or Rebecca and myself or any lawyers who are experienced with data breaches and privacy breaches, just having someone help guide you through that process and reassure you that you're complying with your legal obligations. So as we flagged before, there are a lot of helpful tools in the New Zealand space which help you navigate that yourself, but it can always be helpful having a lawyer assist you through that process and really analyze the context of the security breach to make sure you're doing everything that you can and in compliance with your legal requirements. And beyond that, lawyers, so myself and Rebecca, can assist with preparing data breach response plans so that in the event of future breaches, you have a really clear process in place. And we can also assist with reviewing your impacted contracts, so things like your privacy policies to see what's in them and whether we need to flesh out those and add more detail around any potential breaches or your contracts with your suppliers or any third parties, and whether there are any reporting requirements or processes within them as well. So having a lawyer on your side can just be helpful navigating the whole process, making sure that you're crossing all your T's and dotting all your I's in the way that needs to be done.
For sure. Okay, we've had, this is a really, really interesting one. I like this one. What if using a cloud hosting service such as GCP or AWS to host an app and the host has a data breach? Who is liable? This question comes up quite a lot, actually, because I think people would love to be able to just offload all of their responsibility to their hosting provider if the breach happens there. And it's not a straightforward answer, to be honest. It's quite nuanced. So sometimes it is possible that the whole liability will sit with the hosting provider in terms of if AWS, for example, had a critical systems breach, and that's where the cyber attack came through, and it took a whole bunch of data that way, then AWS does have a responsibility towards you as their customer around losses associated. Often the contract for hosting with AWS or GCP will have limitations on what they're liable to you for. So it's really important you have some legal review on that contract to know how much your risk is, and therefore how much insurance you might need to carry to be able to do that. There is also sort of like this knock-on effect where, sure, the data breach might have happened not because of your systems, but because of your hosting platform systems. But that doesn't mean you then get to disregard all of your customers or your suppliers or your contracts or your information, because you're the one who knows about the breach. Your customers might not. So when you are notified of the breach, you still need to do your own internal assessment of which customers have been impacted and how, and then you have a duty to notify them. Just because you weren't responsible for the breach doesn't mean that you get to sort of be absolved of all your responsibility around notifying people of that breach that's happened to them and sort of having those bets. So it's a very sort of multi-part question that you deal with on a case-by-case basis a little bit around, okay, how much of the responsibility can I shift onto this provider who has had a breach? How much of the responsibility do I need to wear? And that can depend on what kind of contracts and data and breach has occurred. And that's where sort of having some on-the-ground advice fairly quickly can be helpful so that you can know what losses you need to mitigate and also what steps you need to take to be able to perhaps claim back some of those losses. To be honest, the AWS contract is generally quite robust in terms of protecting them from any claims from you, just in regards to the volume of business that is handled there. So it's not always possible to be able to rely on that. It's definitely important that you take care of yourself first. Alrighty, we've also got another question, which is around New Zealand's laws or penalties seem a bit behind Europe and Australia, etc. Are there any changes in accountability or increase in penalties on the cards for New Zealand? The honest answer I have to that is I don't think so right now. There definitely seems to be a trend around public attention on privacy. Our privacy principles are fairly closely aligned to Australia's, to be honest. We've got some fairly, robust principles in there, but they're not sort of up to Europe's standards for sure. We do see that sort of the European standards reach into New Zealand, for example, like we have the EU GDPR, which we have to comply with in New Zealand if we're going to be dealing with, information coming from EU residents. So we do have some obligations towards that global law. What we're seeing the trouble with, though, is really around enforcement and penalties associated with that. So the penalties domestically in New Zealand certainly are lower than what we see in some of these sort of European pieces of legislation. But at the moment, as far as I'm aware, which I'm very open to being proven wrong, there's no sort of bills on the table at Parliament that would suddenly massively increase this. Our privacy laws are being looked at and iterated constantly in terms of we've just had an update come through in June. But as far as penalties go, I'm not aware of any major changes currently in the works. All righty. We also have, okay. In the context of managed web hosting, to what extent can liability be effectively limited through terms of service alone? Is that sufficient to forego the need for cyber insurance? I think that would be very specific to the circumstances, and what your website actually does, or what your, hosting, what is it that they're hosting for you? If it's a regular website that doesn't really have customer intake data, it's just advertising for your business and nothing else, then yeah, probably you could just sort of deal with the fact that your website might be down for a little while, or it might be impacted for a while, or you might need to redo it if you feel like you can redo your own website fairly cost effectively and you don't want to bother with paying an insurance policy. But then if you're dealing with things like, maybe you're a software provider, if you're a software as a service provider, you're going to want to have your own cyber insurance around downtime, because that will affect all of your customer contracts. Um, if you're someone who's collecting a lot of that personal information, and you're a high risk business in terms of collection, you're definitely going to want insurance. So that's really specific on what it is that you are doing as a business as to whether or not you can go without cyber insurance. And also your risk appetite as a business. Like, when you're a startup, sometimes it's not that commercially appropriate to be investing in it. Sometimes you can't afford not to invest in it, and it needs to be done there. So I think that's unfortunately probably very specific to what it is that you are doing as to whether or not you'll be able to rely on your hosting provider to cover you instead of insurance. And then I think that's all of the ones that we can answer today. There were a couple that we can't answer because they are too specific, unfortunately, to your circumstances. But if there is something that you really have a burning question that you need answered, and we haven't been able to do it today, then please feel free to submit your details and in the survey at the end. And that way we can be in touch with you about how we could provide further assistance. Please also submit your details at the end if you want to claim that complimentary consultation. And then also, as I mentioned at the start, please complete the survey. We really appreciate your feedback. It helps us improve what we provide to you on a regular basis. And we know it's hard to part with your time on a regular basis. And so we really appreciate you joining us today and learning more about how to protect your business against potential cyber threats. I will look forward to chatting with you all next time, either as a member or on our next webinar that I am involved in, and really appreciate your time today. Thank you all.